Hi students, so I am going to make lectures for each of you who might need them or just want to look at them regarding past lectures we've done in class. This might help you prepare and also maybe just clarify certain things that you were a little bit unsure of. So we're going to start with day 2. I'm going to do it week by week. And day 2 was the history of victimology. I know that the first day was like an introduction, but basically that wasn't anything specific to elements you need for the course exams or materials. So let's start with day 2, the history of victimology, and I'm looking at the PowerPoint. So that's probably the best idea too, is to reference the PowerPoints as we go. Always remember your resources, so I'm always going to put the resources, and the 3 that I think are most pertinent to our class are going to be the Title IX coordinator, and that is Nicole Rios, the Office of Counseling Services here at High Point University, and then the Family Justice Center, which has offices in Greensboro, I believe in Winston-Salem, and also locally here in High Point. Okay, so victimology, just again, is a subfield of criminology. And in class, we did discuss the difference between criminal justice and criminology because they are separate, though they work together. And so here your major is criminal justice or your minor. Whereas others, it might be criminology. And so criminology really is the study of why people commit crime, and it borrows from disciplines like psychology, biology, sociology, and a combination of those disciplines. So it really looks at what causes crime. It postulates theories, conducts research, and tries to assess the efficacy of different policies. Whereas criminal justice is kind of the reactionary field, though just equally as important. They are comprised of our system. So our police officers, our judicial branches, our probation, parole, corrections. So they work hand in hand and they go together. But really, victimology is a subset of criminology, not criminal justice, although when they're conducting investigations, police and detectives often look at the victimology. They'll look at the victim and getting to know them to assess the clues that they were given and give them some maybe possible leads as to what was or was not significant in the victim's life. Okay, so we're going to look at some of the causes of victimization without blaming the victim. We're also going to look at the consequences and how we treat victims in the criminal justice system as well as in society. And we'll look at policy suggestions or improvements that we can make. Okay, so the history of victimology, we look at when this was first coined as a term or defined as such, and that was in 1947 by Benjamin Mendelsohn. And I did list the 5 reasons for punishment on the board, so just to reiterate, the 5 reasons that we see or justifications for punishment in the criminal justice system: deterrence, incapacitation, retribution, which is an eye for an eye mentality. We have rehabilitation, which follows the medical model and tries to fix whatever is broken with the offender. And we have restorative justice. And the last one is where we see kind of an attempt to have mediation between the offender and the victim and restore the harm done to the victim. Okay, and so the reason you need to know that is because we're going to talk about kind of the early field or stages of victimology. Even though in the US it was coined in 1947, and we've actually studied a lot since then, we do acknowledge that victims have been, in existence since the dawn of time, because crime has also been ongoing. So before the 17th century, or up until the 17th century, the burden of proof and of solving the matter fell on the victim. We'd often see this retaliation. So we'd see one family acting out against another, and it really followed that retributive or an eye for an eye mentality. In the US, though, people think that it's harm done against the victim. When you go to the criminal justice system, however, it's actually a crime against the state because the offender violated a written code or statute, and that is considered a behavior that was prohibited by that state or jurisdiction. So the victim does not, when you go to trial, for example, if I was the victim, it wouldn't say Piatak versus the offender, it would say the state of North Carolina versus the offender. And so I did talk about my case, and that was where I had my wallet stolen. A very long story, but I was supposed to get restitution, and this was in 2017. It is now 2023, and I have not seen a dime of that money. But that is restitution, so typically it'd be a financial repayment to the victim. And it's supposed to come from the victim. Okay, we also had the Code of Hammurabi, which was one of the first codes that looked at the victim, and it had early concerns and considerations for the victim. However, when we move into early victimology in the US, we really do start to see what I would consider a little bit of victim blaming, and so I would just caution everybody to be very compassionate here. Okay, so there's roles of the victim, there's victim precipitation, and that's just the extent to which a victim is responsible for his or her victimization. So I don't love that. Victim facilitation is when somebody would unintentionally make it easier for that victimization to occur. So for example, if I leave my keys on top of my car and walk away, it's much easier that somebody could then steal that car. Victim provocation, though, is, as the name implies, when the victim provokes the aggressor. So let's say you're at a bar and somebody gets in a fight, and the victim is the one who started the fight, but then the person they're fighting with retaliates against them and the victim is harmed more, right? That is victim provocation. So when we move into the father of victimology, people will say Hans von Hentig as well, but really Benjamin Mendelsohn is the one who coined this term, and that's, in my opinion, the actual father of victimology. So he was an attorney, and he conducted a lot of interviews with both victims and offenders to try and understand that process, what happened, and look at culpability. And then it says, fun fact, it's not very fun, but the term victim was first used in the year 1660. Okay, moving on to his classification. The completely innocent victim would be a child, an animal, an elder, somebody who bears no responsibility at all. The victim with minor guilt is usually victimized due to ignorance, maybe being in the wrong place at the wrong time, which you wouldn't necessarily know. But another example is if you frequent a bar that is known for having a lot of violent altercations, right? That might kind of, I wouldn't say justify or give any reasoning to blame the victim, but it would explain maybe why they were at a higher risk of victimization there. The next one is the victim as guilty as the offender. And so I did give you the example of Muse and Brandis. They were the German individuals who agreed to that cannibalism. So remember that video from class. The victim who is more guilty than the offender is the one who provokes them. So we talked about this before, somebody starting a fight, but then not being the successor in that. The most guilty victim is allegedly the one who was victimized while committing a crime. So we have your stand your ground laws here. If somebody were to break into your house and then you use lethal force, again, the person would seem like the victim, but really they started that by going into your house. And lastly, we have the imaginary or the simulating victim who fabricates victimization. People often think this is the case with most victims of sexual assault, but according to the FBI, only 2 to 8% of victims who report their crime are misleading the police or giving non-factual information. So most people are, but most people will not report rape. All right, so we also have the early studies with victimology. So we have Wolfgang and homicides in Philadelphia. So for him, victim precipitated meant whether or not the victim was the first one to brandish a weapon or strike the other person. And he found that was the case in 26%, so a little over 1 in 4 victims. The relationship was that they often were 2 men, so it was often male and male in his studies, and usually they knew each other. They weren't close friends, but they had an argument or something, and usually that argument was facilitated by alcohol. Amir looks at this. He's a student of Wolfgang, and he looks at the same thing, but with rape, and he looks at Philadelphia. Again, remember that most rapes are not reported. So victim precipitated for him would be if the victim acted in a provocative manner, which, again, don't love that wording. However, 1 in 5 rapes fit that category, but the important thing that gives him a little bit of credit is that he says it actually is not the victim's behavior, it's how the offender interprets that behavior that matters. Okay, the next one, I played videos in class, so hopefully you all remember. We'll put them online too, but we had the Sherman and Burke investigation, or a study rather, the Minneapolis domestic violence study, which is very popular. If you ever study victimology or domestic violence in another class, you'll probably hear of this study. So Sherman and Burke looked at Minneapolis. So in the 1980s, intimate partner violence was rampant, as it may or may not be considered today. However, police really took a standoff approach. They said it wasn't their business, it was a family matter. And so the impetus for this was that there was a lot of IPV, and in Chicago alone, in the 1980s, 4 officers shot and killed their wives. So that's a really alarming number. And we also had the case of Tracy v. Thurman. I played that video, and there's a description there, but basically the law did not protect her. She'd had multiple restraining orders. The guy showed up to her house. Her husband did, threatening her. She called the police, and remember, the old man responded, the older police officer. He first went back to the station to use the bathroom. This is an urgent situation. He gets there and she's being stabbed, and he hides behind his car. So it wasn't until neighbors intervened. Luckily she lived, but again, she was paralyzed. Okay, so the actual experiment is based on deterrence theory, which again postulates that punishment should be swift, severe, and certain. And they looked at misdemeanor cases of intimate partner violence or domestic violence, not felony cases, which would usually warrant a more severe response. So they were supposed to use random assignment, where the officers would, if the case fit this, they would have to then take a random envelope and either arrest, advise, which would be giving them counsel or information, or separate them for at least 8 hours. They didn't actually follow that protocol, but in any case, they interviewed the victim 6 months later, and it seemed as though it had worked, and that their partners had perpetrated less violence in the subsequent months following that arrest. Still, Sherman and Burke advocated against people making knee-jerk reactions and instilling, or creating rather, mandatory arrest policies, but their advice went unheard. So a lot of states just created mandatory arrest policies where if the police officer comes and they're in a jurisdiction with that mandatory arrest, that they have to arrest somebody. That can be a problem if the victim and offender have both been arguing and they can't tell who the primary aggressor is. We might see a dual arrest in which the victim is also arrested. So they replicate this in 5 cities: Miami-Dade County, Omaha, Nebraska, Charlotte, North Carolina, Milwaukee, Wisconsin, and then Colorado Springs. So when they do this, the one that really stands out is Milwaukee, Wisconsin. So they change it a little bit, still misdemeanor cases only, but they can do a full arrest, which is when the individual would stay until they're eligible for release on a $250 bail. Short arrests are supposed to be released as soon as possible, and that they wanted it to be within 2 hours of the arrest, and then warning just meant that they were not to be arrested. They were just given a warning that the police said, hey, if I come back here tonight, you're going to be arrested. So over time, they see that escalation increased, and this was especially true for individuals who did not have stakes in conformity, so partners who did not have a job or who did not have good standing in the community or good reputation. They had less to lose, and so they were more likely to engage in violence against their partner. And we saw that 23 years later, the victims in the Milwaukee case whose partners had been arrested died at higher rates than other victims whose partners had not been arrested. And we talked about this in class, but it was not due to violence. It was actually due to the stress that this took on them. And so they died of heart disease more often than not. All right, so that's all for history of victimology. We're also going to look at victims' rights really quickly. I'm not going to quiz you on the specific ones and knowing all of them, just knowing basically the overall gist of what this means. So this really started to occur in the 1960s when we started to see people paying attention to victims and also civil rights. So in 1966, this is important, the President's Commission on Law Enforcement and the Administration of Justice really paved the way for the National Crime Victimization Survey. The women's movement did a lot of advocacy, so females working for females and trying to improve their treatment in the criminal justice system, and they opened their own rape crisis centers and domestic violence shelters. The civil rights movement is often mentioned in this, and the reason for that is because while we're also advocating for women's rights, they were advocating for all humans' rights, and so it forced victimologists to recognize that a victim was not just a white female. There's other categories of victims, different races, different sexes and genders, religion, background, socioeconomic status, etc. So the next page does give a lot of information on early programs, and that's important to know. But the next, so slide 6, where it talks about policies, is really important. So in 1980, Wisconsin was the first state to pass their own Victims' Bill of Rights. We also have the National Crime Victims' Rights Week, and that has been going on since the 80s with President Ronald Reagan. We also spent a lot of time looking at the Violence Against Women Act, or VAWA, and you all did an activity in class, if you recall. It's been reauthorized multiple times, and we looked at the Sexual Assault Forensic Evidence Reporting Act and how they established a protocol through the FBI. And then with modern rights, federally and through the state, basically these are some of the big ones. So one, you have the right to be protected from your perpetrator, right? Or to the best of their ability, police are supposed to help protect you. You have the right to be present at trial and court hearings. You are to be informed of those medical and social services that you are eligible for. To know the status of the investigation, which is certainly something you'd want to know. The right to be informed in a timely manner of any plea bargain deals. The right to be treated with fairness and with respect for the victim's dignity and privacy. And then in North Carolina, I thought it was really interesting. A lot of these are the same, but I wanted to note that on slide 10, it talks about the victim having to have written request in order to be notified of the release of the offender or the escape of the offender. And I did show you online how you could do that. You could go and find the offender, and you could also request that, which I'm not sure would satisfy that requirement for a written, but it should. All right, so that is week 1. We're going to move into week 2 next. Thank you.